either in a personal or a professional sense, has had trouble dealing with legal language. And as for myself, I was a lawyer in Sydney for a number of years, and then I moved into academia. And I'm able to use that legal and business professional communication now. And I can remember being a junior lawyer, how, we had no education at law school. So back in the 1990s, we had no legal communication education. We had to acquire it through, a process of apprenticeship practice as well. So lawyers learn how to negotiate and draft contracts, process with other lawyers. And I reflect on that, and I really wish we had have had education in legal communication, how to structure documents and how to draft legal documents. Unfortunately, we didn't, because law exam questions involve cases, and we use the IRAC issue, rule, application, conclusion framework in order to answer those case method questions in law exams, and that would have been very helpful as well. So research has shown that graduates come out of law school and they're kind of familiar with certain genres within legal practice, but they're unable to really communicate effectively until they get into the workplace, and then they go through this process of apprenticeship to be able to communicate effectively as lawyers. And these challenges are much more difficult for all of the law students in non-English speaking background countries that, will eventually have to use English as the lingua franca in a globalized world. So they'll have to use English to negotiate and draft contracts in professional practice. So that's the background to this presentation, is that, legal English, business English should be an important part of the education of law students, business students, and that's what I've been able to do. I spent almost 10 years at Koç University in Istanbul, and now at Nagoi University of Commerce and Business, I'm able to bring my research, applied linguistic research, into the classroom in order to teach students how to function as professionals once they graduate. So mumbo jumbo, the language of law together with religion. And there's a nice quote there, that law is both relentlessly formal and relentlessly conservative. So, and then we refer to it as legalese, as a kind of archaic and jargonistic type of discourse. Now, why has it developed that very unique and complicated and complex way of communication? There's a number of reasons. One is that, legal texts need to anticipate a number of different possibilities. If we're too precise, in a sense, we can't accommodate different real life scenarios that laws should regulate. So it's quite a difficult medium to develop in order to achieve its purpose. And so in order to achieve that purpose, we can see that it's developed these very complex syntactic properties: long sentences, normalization, passive voice. I think you're all familiar with the type of language I'm talking about if you've ever had to sign a contract or understood a piece of legislation. So in some ways, the complex nature of legal discourse serves an important function for these reasons. However, historically, the complex nature of legal discourse has very kind of selfish reasons as well. I mean, lawyers wanted to separate themselves from people in society, referred to as lay people. So it was a kind of way to reinforce the significance of the profession, if that makes sense, that only lawyers can deal with legal documents because only lawyers can speak this language. We've been trained to speak this language. It's been designed to perpetuate that bubble, that professional bubble around lawyers. And, you know, and with that comes a very secure, a very secure professional income as well, because if only lawyers can function as lawyers, then, you know, they can make the money from being legal professionals. So it has a functional reason, but also a very kind of selfish professional reason as well, why Legalese has developed the way it has. However, you know, in the 1960s, we've come to understand the importance of making legal language simpler, to make it more accessible. So the beginnings really related to legislation. So the consumer movement in the United States in the 60s to the protection of consumer rights was the first real step into trying to, and that's really basically a consideration of audience. I mean, consumer protection legislation is designed to protect consumers, normal people in society. So in order for the legislation to have to be effective, we need to make the language. Okay, and then banking as well. You know, again, a consideration of clients, banking customers. We can see in the 70s that banks started to slowly modify their contracts to make them more simpler to understand. And then the UK caught on in 79. The UK organised very formal organisations designed to work on the simplification of language within British laws. So we can see that happening in the late 70s. And then Australia had also developed in the 70s and 80s as well. So we can see the Australian Office of Parliamentary Counsel was set up to make the shift to plain English. New Zealand as well, and then in Canada, South Africa. This is all happening in the 80s. So I think the takeaway from here is once the UK started, then Australia and then New Zealand and other countries caught on. The EU in the 1990s, and we have the plain Swedish group, for example. So we can see this plain English movement really taking shape, gathering speed through the 80s and 90s, primarily to make the language in legislations simpler and more accessible to people who are using that legislation. However, the focus of my discussion today is more on contracts within the business world. So this is what I've done. This is what I've done at Koch University and at NUCB, is because I teach, you know, business students. They're not going to go in, they're going to be using contracts. So in recognition of their needs, their professional needs, you know, my pedagogy, my teaching is focused on contracts rather than legislation. But the same principles apply. Consideration of audience contracts, they should be simple and clear for the people who are going to be using the contracts. So that relates to style, structure, terminology, and the level of detail within contracts. Yeah, so that's the basic rationale, isn't it? That you're creating contracts for business clients, and they should be able to understand the contracts and feel comfortable using them, yeah? Rather than making them too inaccessible or ununderstandable through Legalese. So it's not just about business, it's not just about business clients, business professionals, but consumers using contracts as well, because and we can see that insurance companies, the NRMA, in recognition of the needs of their consumers to understand the actual insurance contract, we can see they were the first to really convert policy documents to plain language. And that happened about 25 years ago. So it's a really practical consideration, practical necessity to make contracts simpler. And then banks have been a little less, have been more reluctant to change, but there was a recent court case where the contract was not enforceable because it was basically the clients couldn't understand it. So even though the contract can have a disclaimer saying, yes, I've read this carefully and I understand the document, once the court looked at the actual language, the terms and conditions in the contract, they were able to evaluate that to understand the contract. So that's a very persuasive message for banks to change their language within contracts as well. So this is bringing plain language into the classroom, and we can begin with making the structure more coherent to understand, and that begins by using effective headings. So it's the look and feel of the document. Also defining the headings very clearly, effectively. Making sure that key terms are capitalized throughout the contract. And I see that quite often. You can see contracts and the drafting is very sloppy, but tightening up these very simple but effective elements to the contract can really help with understanding as well. So effective headings, key terms are capitalized. Definitions, so the definition section in a contract can be really helpful because you want to take a lot of the detail out of the body, the operational part of the contract. So when you're defining the terms and conditions in a contract, what we're trying to do is take a lot of the detail out of it. So if we do need to define key terms, we can have a separate definition section where we can be detailed in how we define those terms. And then we just use those terms capitalized throughout the contract so people can use it. And, if it comes to a question of interpretation about the definition, then, ultimately the courts can look at the definition within the definition section if necessary. So terms and conditions, complex clauses, we can break them down. It sounds obvious, but, for the reasons we've discussed, we can see clauses which are 10 lines long, for example, with all these very complex syntactic properties within the clause. But, we can unpack that and then repack it in a very simple clause structure with subclauses, any effective numbering. Okay, and the last one also relates to taking detail out of the contract. If we need to explain a process or if we need to define it out of the main body of the contract and the end of the contract, and then we can just refer to those details at the end. So, we can start by teaching students how to structure contracts more clearly and more effectively by doing these simple things. So we go from macro into micro, and this is where we're changing the language within the contract. And these are elements that we can focus on. So we can eliminate archaic and Latin expressions. They're not necessary at all. So let's replace them with simple language, accessible language that people understand. Reduce this to connect shorter sentences. What I was talking about previously, we can remove unnecessary or repetitive words, either by putting them into a definition section or an appendix, or just deleting them entirely if we don't need them. In terms of grammar, we can reduce the use of passive forms, reduce normalization, make sentences more active in a grammatical sense. We can personalize contracts. I'll come to that in a minute. And everyone, I think, is familiar with this unique use of shall within legal discourse. Again, we can replace that with simpler language, and then ensure that text is gender neutral as well. So yeah. Now, as I said at the beginning of the presentation, certain legal terminology we can't change because it's been developed in order to either to explain a very complex social process or legal issue within a very specific term. So that very specific term can encompass a very broad meaning which relates to that particular term. So some things we can't take expressions. So, words like warrant or force majeure or indemnification, we need to use that legal terminology. So, we can provide a list of legal terms that we can't replace in contracts. So students and then they can focus on those terms so they're very fluent in using those very important terms as well. But there's so many examples of contracts that we don't need. So notwithstanding anything to the contrary herein and subject to the foregoing, So it's basically not necessary. It doesn't make sense. All it does is function to confuse the reader. Unnecessary details, unnecessary language. Yeah, so let's make sentences active. Let's make language active rather than passive. It makes it much easier to understand. It's clearer. It also identifies the subject much more clearly. I know there are instances where the actor, the subject, is not relevant and that we're focusing on what has to be done. So passive does have a role, but I think for the majority of the time, we don't really need it in contracts. Okay, and these ways to improve the language of contracts can also apply to other types of writing. So students also are taught how to develop a letter of advice, where lawyers give advice to lay people, clients. And so these principles can also be applied to different types of legal writing, legal genres as well. Normalization. Again, there are some very unnecessary length we don't need to use. And that involves making the sentence active, subject, verb, shorter sentences, use conjunction to join them together. So yes, again, normalization does have a role, does have a function, but we don't want to overuse it to the point where it becomes difficult to understand. Okay, so clearly identifying the parties is a very simple but effective way. We bring the parties as the subject at the beginning, making sentences active. So, expressions like the parties agreed to, it is agreed, the parties shall, we can remove that archaic, unnecessary language and make sentences more active. Now, yeah, this is cool. This is a very perhaps notorious term used in contracts. Lawyers love to use shall when drafting contracts. They sprinkle it around in documents like some sort of pixie dust. Sorry, I got this quote from somewhere. I haven't referenced it. Hoping the verb will magically make the document seem more lawyerly. Okay, but the reality is that shall has multiple meanings. So let's use the proper verb to represent that meaning. So, shall can also mean may, as in no person may read this. As an equivalent for the possible future event, will. one party will breach, if the party breaches the agreement, to express an entitlement and not an obligation. Entitlement rather than an obligation must. The prevailing party shall be reimbursed. And as a substitute for should. Okay, so sometimes what we're trying to express is a recommendation rather than a mandatory obligation. So the message here is, let's replace shall with things like must and will and should and is entitled to. Gender neutral text. So this applies more to legislation. I think we can see the movement in the UK. And here's an interesting quote. This is the Blair government, I think. So we have Jack Straw, member of the Labour Party, I think. Is that right? Anyway, male pronouns are used on their own in contexts where reference to women and men is intended, and words such as chairman are used for offices capable of being held by either gender. Many believe that this practice tends to reinforce historic gender stereotypes. Good. That's a very gender neutral. However, a Conservative opponent had different ideas. And this is Anne Widdecombe, Conservative MP for Maidstone and the Weald. Jack Straw is a silly ass. A chair is a piece of furniture. It is not a person. I'm not a chair because no one has ever sat on me. All he is doing is distorting himself with everything. And this topic as well, the plain English movement, there's going to be different opinions, different perspectives about the need to do it. And, you know, a lot of lawyers are reluctant, of course, for the reasons I've talked about. A lot of lawyers are reluctant to change as well. You know, mainly for that historical reason, to preserve the professional aura they've established historically over the years. So the separation between lawyers and lay people, a lot of lawyers still want to do that. However, you know, consideration of audience, consideration of clients, we can all agree that it's a necessity. And the good news is that things have changed dramatically from the 70s, 80s, and 90s. I'm unable to provide any statistics as such, but we can see that if we analyze legislation and current contracts, they're much simpler and easier to understand previously. So what I was hoping to do was, you know, going back to what we to these issues, eliminate archaic expressions, reduce sentence length, remove unnecessary words, reduce the use of passives, reduce if anyone is attending, is to do some writing, to do some drafting. Is anyone here? Maybe not. But on the assumption that everyone, if anyone's here, can read that, can we redraft that? This is an audit clause. Okay, so Kevin's here and EIB is here. Would you like to spend a few minutes redrafting this clause, thinking about what we've talked about, reducing unnecessary language, reducing the use of passive, normalization.
And Anthony,
and I think this could help us. Yeah?
Okay, can I ask you a question
Hello?
before I get started? Oh, thank you. Oh, sorry, let me turn on my video.
Yeah.
No, can I ask you a question before we get started on this? Because you made some really good points. And one of the things when I'm reading through this, I'm thinking, what words cannot be replaced?
Mm.
Are there any words here, because you're the expert and I am not, and I'm struggling with, can I replace principle? Can
Okay.
you know what I mean? So
Yeah.
from the legal perspective, I would not know.
No, we can't replace the party names because, the principle will be defined by the person's name and business address in the preamble to the contract. But what we could do, going back to the structure of a contract, if we capitalize terms, it makes it more easily to identify them in the terms and conditions. But we don't want to replace principal or the agent, no.
Okay, thank you. That's what I wanted to start with. And so is there anything else here that you would consider to not be replaceable? Otherwise, I'm really tempted. Oh, you've already showed us. Okay. Okay, thank you. Yeah.
No, I don't want to hold you back. But what I've done here, I've taken apart the clause into 4 different sections and identified, things like shall, normalization, unnecessary language perhaps to help you. Okay?
Very helpful. Thank you so much.
And also, that's the original clause, but in order to help the process, I've unpacked it a little bit for you to more clearly go through.
No, this is very helpful.
And then
for sure.
if we can put them on chat, if we put the redrafted clause on chat, that'd be good. Also don't forget, we talked about using sub clauses, yeah? So even this is clause 10, we don't have to do it all in one. We can have 10.1, 10.2, 10.3 if necessary. So maybe 5 minutes? Or yeah.
Okay, one thing, Anthony, that might be helpful, because it's easy to edit if the text is in the chat. People can just copy and paste and edit. Is it possible to put this text in the chat?
Okay. Okay, I'm going to stop sharing. Yeah? Can I stop sharing?
Yeah, you can. I think you can escape and stop sharing temporarily.
Just a moment.
It's a good idea to put it into chat, because I was trying to copy and paste from here and I can't. So yeah.
Oh, that was the answer.
Okay.
So sorry about that. Chat.
No, that's fine. I think we're all.
Is that right?
Learning and doing our best. So.
Yeah, maybe. There we go.
All right.
And I'll put the that modified version up as well.
Okay.
Okay. Oh no.
That's fine. You don't have to, I guess, be too. It's okay. We do have. Yeah, I pressed the wrong thing when I made you the host, so it's easily enough done. All right. So we've got so we still have about 10 more minutes for the entire session. So yeah, I guess
I'm looking forward to face.
Yeah. So if we can work on this for the next few minutes, as Anthony suggested, that might be very useful until maybe 10:25. Is that okay, Anthony?
Hey guys, this is Forrest. I'm the host for the next presentation. So let me know
Yeah.
how I can help you. There's a checklist I'm supposed to go through, but
Okay.
if you guys need to work still, that's fine. I'm
Yeah,
here.
that's good. That's good. Yeah, we have 5 minutes, should be enough.
So Forrest, what time do you start the session?
Well, it says from 10:30 to 12, right, on the schedule.
All right. So then, Anthony, I'll need to apologize.
This next session starts right on 10:30.
Yes. All right. So I guess now for the next few minutes. So maybe if we can wrap this up in a couple of minutes, Anthony. So sorry to rush you. Yeah.
Get out of that.
No, because yes, I guess one of the things to be mindful of is
No, that's fine.
the next session is starting immediately when this session finishes.
Yeah, and I've got a whole checklist of things I need to go through with the presenter. So we need quite a few minutes for that. So.
Okay, so if you give me a couple of minutes to wrap this one up, we should be finished. All right. So Anthony, my apologies for I guess short-circuiting your activity there. But I'd like to thank you and Kevin both for your presentations today. And I think that this idea of plain language is something that is occurring with the rise of non-native speakers and English varieties, where a lot of these varieties of English do speak or do use a plainer version that is, and they're not so beholden to more traditional, so they're not, maybe in like in Indian English there might be some legalese in, if you're an Indian lawyer, there might be some link to wanting to use that, but I think in everyday communication it is indeed very useful. Yeah,
globalization is fueling the movement as well.
And if you think of the number of non-native speakers versus the number of native speakers, even native speakers are likely to be interacting in a more accommodating environment. So this sense of accommodation, language accommodation, where you are speaking more plainly and clearly, is definitely a thing that I think will increase. Okay.
And so I think the relationship. Sorry, one last thing. The relationship with clients is different now too. So, the customer is right. So if the customer wants to be able to understand the contract without additional costs, then, lawyers need to meet those requirements.
Okay.
Thank you.
So yes, again, thank you very much for the very informative presentations here today. And thank you both. So Anthony as well, I'd like to extend an invitation to you. Maybe I'll chat to you a little bit afterwards, but as soon as I hand over to the next, so let me make the next person here the host. So yes, if we can,
I can reclaim it.
Thank you, Michael.
Yes, no, thank you, Anthony.
Thank you, Kevin.
Thank you, Kevin.
No, thank you, Anthony. It was really, really wonderful. What I realized also is how valuable your expertise is as well.
Yeah.
Okay.
Sorry, guys.
You can tell us. Okay.
Sorry, guys. I got to take over the room. You can go to. There's a main lobby you can go to and continue the discussion if you'd like. Okay.
Okay.
Thank you so much. Okay.
Thank you. Bye-bye. Okay, guys. Oh.
Hello, Forrest.
I didn't mean to. Didn't mean to record.